Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to today's sitting of the Appeals Court. Let me begin by introducing the panel to you. To my right is Justice Mary Sullivan, and to my left is Justice Sabita Singh, and my name is Ariane Buno. I think we have experienced counsel here today, but I'll remind you that each side has 15 minutes to present their argument. There is no rebuttal in the appeals court. You can be assured that we've read all the briefs and all the appendices, and in some of these cases the record was voluminous. We're familiar with it, so you can get right to your points when you come before us. The first case we have today is number 2022-0663, Kirby Mastrangelo versus others and the City of Amesbury and others. Counselor?
Morning, Your Honors. May it please, members of the panel, may it please the court. My name is Richard Mestone. I represent the appellants. This is my co-counsel, Attorney Stephen Marullo.
Good morning.
This case arises from the unsuccessful efforts of the appellants to obtain a host community agreement with the City of Salem and then the then Mayor, Kenneth Gray. We had filed a complaint in 2018 whereby the defendants had filed a motion for judgment on the pleadings, and 2 counts out of 5 survived, count 4 and count 5. Count 4 being intentional interference with advantageous relationships, and count 5 being the declaratory judgment. As this court's well aware, the elements for intentional interference basically are 4, and I'm going to take them in various orders at this point. The first point I'd like to make is that the first count stating that they had an advantageous relationship with a third party, any business that operates or wants to operate a marijuana retail establishment has to get licensure from the CCC, the Cannabis Control Commission. And in order to do that, they have to submit an application. In order to submit an application, part of that application is a host community agreement. You can't submit an application without it, or it'll be rejected. The appellees believe that they didn't interfere with any kind of advantageous relationship because they're stating that there isn't an advantageous relationship. They're saying that EE status alone, economic empowerment status that is, isn't sufficient enough to create a concrete relationship. But, excuse me, the relationship between the plaintiffs and the CCC is not a typical relationship. There is an advantageous portion to it because the appellants are experienced in this type of area, and they're looking to do this for financial gain. Aside from that, it's not the appellees will state or have stated that they didn't interfere with us having EE status, that still exists. That's quite true. It's not that we're arguing here. It's the fact that they've blocked the use of the EE status so that we can't apply or take advantage of that with the Cannabis Control Commission. The significance of that EE status is the fact that we get priority status or priority review at the Cannabis Control Commission. Once we submit that application, other than medical purposes, they look at our applications first. And if any of those are incomplete for the requirements that are made, they just reject it, so you don't even get any kind of preliminary licensing or permanent licensing. That's what we're looking for as far as the interference portion. The second 2 prongs of the elements are that the defendant knowingly induced the breakup of the relationship, and that the defendant's interference was intentional by improper motive of means. I'm going to address those together because they pretty much run hand in hand. The lower court's decision stated that the crux of the case was whether the appellants could show actual malice and that the record was insufficient to show that Mayor Gray actions were spiteful or malignant. We disagree. We believe that the lower court erred when it granted the appellee's motion because a claim for international interference with advantageous relations relies on Mayor Gray's intent. And in Quincy Mutual Fire, the case, the granting of a summary judgment in a case where the party's mind or motive constitutes an essential element of the cause and the action is disfavored. It doesn't mean that you can't do it, but it means that you need to look beyond certain things in order to find out what's going on.
Now, the judge relied on malice as being the intent that was required.
The appellees are arguing that there wasn't any evidence of malice, that we didn't argue anything with malice. We're saying that the malice standard is improper in this particular case because all of the cases that we reviewed, the malice standard has been applied in employment cases. We don't see anything where it's applied anywhere else. And we believe that this is not an employment case. None of the parties are employer-employee, and therefore we think that the court erred by taking the actual malice standard. In fact, go ahead.
What's the most analogous case where you can show that this improper motive means?
Well, United Truck Leasing, they basically stated that they did away with that. They abandoned the word malicious. And in abandoning the word malicious, they used the word improperly. And improperly ties into one of the elements where they're talking about it being improper in motive or means. In Blackstone, they refer to the court coming back to that standard, but again, when it came back to that standard, it was all in employment cases. In fact, the dissent in the Blackstone case...
Counselors,
if I could, I'm looking at footnote 3 of the judge's decision at page 8 of Record Appendix 4, and he notes Blackstone and Weber, but then goes on to say that the malice standard has been applied in the municipal context and cites Cachopa and Howcroft, and says, quote, notably, the plaintiffs have not argued that the standard does not apply in this case. So my first question is purely procedural. Did you argue to the judge to the motion judge that this standard didn't apply?
At the time, we were talking more so of improper means and improper motive. The word malice actually came up at the hearing. With regard to the Topcha and the other case that you had mentioned, those again are employment cases. They're employee-employer within the city that they're dealing with. So again, it's not in a context of a third party coming in and dealing with them. The argument is that there was no evidence presented in any of the pleadings that show improper motive of means. We disagree with that. We believe that the actions of the mayor, which I'll allude to, were executed in bad faith and by improper means. The appellants had approached the mayor after an alternative therapies group, which in April and May had gone in to obtain a host community agreement, and they received the host community agreement. Our clients had gone in to the mayor and asked for a host community agreement after they had had an outreach community meeting whereby they explained to the community residents what's going on and answer any questions that they may have. When they approached the mayor, he said to them that you must go to the planning board and get a special permit. My clients had explained to the mayor that they did go to the planning board prior to seeing the mayor, and the planning board stated that they had to first get an HCA before they can apply for a special permit. Now, while all this is going on, there's an ordinance, I believe it's 2018-15, which was sponsored by the mayor, which put parameters in place on how to obtain HCAs, as well as other things with relation to the marijuana establishments. And one of the things that it talks about, one of the requirements is that a permit holder shall apply for an HCA. That term is a defined term within the statute. A permit holder is defined as anyone who has a special permit or has been granted or has been received a site plan approval from the planning board. When our clients were refused an HCA because they had to get the special permit, in October of 18, that was in June of 18, in October of 18, two other applicants, CNA Stores and Jamico, were given HCAs. When we approached the mayor and explained and the appellate's brief addresses this, that there is no process. Because we explained to them, why are we getting thrown to the planning board, and they're getting it without having gone to the planning board. And it was explained to us that there was no process. But the statute clearly says that, and a deviation from the statute against any of the individuals that we're talking about here is clearly improper. You're not adhering to your own standards. You're discriminating against and having disparate treatment for us.
Does treating applicants differently,
They're treating applicants differently.
is that in and of itself unlawful? Does everybody have to be treated exactly the same?
I believe it is, Your Honor, because it's discriminatory in the fact that discrimination and bad faith can rise to the level of improper
Difference
motive.
between discriminate, the word discriminate means basically to sort out. It's not in and of itself a bad thing. Well, it can be a bad thing if it's done for the wrong reason. And the reason that was given is that there was community opposition because of the location, and that the individuals involved didn't think they could, they wanted the planning board to sort it out because they were getting two divergent stories from a council person and from your client. Why is asking the planning board to perform that function unlawful?
Well, I can explain that, Your Honor. Alternative Therapies Group, which I'll refer to as ATG, CNA, and JAMCO, as well as the proposed location for the appellants, are all within a half a mile to a mile of each other. So they're all in the same area.
But
Yet no
are
traffic.
they all on the same rotary?
They're all on the same road in the general area.
Rotary.
The rotary, Your Honor, is at least a half a mile or more away. When we looked at the area concerned, there are major intersections, but we don't see a rotary up until you get near the police station.
Was there community opposition to the other two applicants?
CNA basically had concerns where they had to formulate a plan, and they filed a traffic study as a result of those concerns. And the result of the plan, or one of the aspects of the plan, was in order to eliminate traffic, what we'll do is we'll go by appointment only. Well, that same plan was proposed by the appellants and rejected. In addition, the planning board had stated that my clients had to endure the cost of widening the rotary, which was a significant amount of money.
Did your clients do a traffic study?
I'm not sure if they had done a traffic study, Your Honor.
So if we could just revert to my other question, was there community opposition, was there councilperson opposition to the other applicants?
There's a dispute there, Your Honor. My client is saying that she attended the community outreach meeting and that all the questions were answered and it went well. Councilor Margraf, who is the counselor for that district,
understand
states
that.
something different.
I understand that, but that's not my question. My question is, was there the same kind of even dispute about community opposition with respect to the other two applicants?
As far as I know, the only other one was CNA, had some kind of traffic dispute that occurred. Whether it was at the level of the planning board or whether it was at a community outreach meeting, I don't know, because those didn't occur until well after the process.
Well, if a council person had complained about the traffic study and the quality of the information, would the mayor have been permitted to send that to the planning board for CNA?
Say that one more time, Your Honor.
If a council person had complained about CNA's traffic study, would the mayor have been permitted to send the CNA application to the planning board?
I believe they did, Your Honor. That's what caused him to send it to the planning board.
All right, so you're saying another applicant went to the planning board?
After they had received the HCA, yes, Your Honor. Because see, the whole system here is that in order to get a special permit, you have to have submitted either a pre-licensure or a license, but you can't get one of those until you apply to the Cannabis Control Commission.
Understand that. So you're saying it's the timing of sending someone to the planning board that's unlawful?
No, Your Honor, we couldn't get a special permit until we had an HCA in hand because of the license.
I understand that argument. It's a separate argument. I'm trying to focus on what you consider to be unlawful about having an applicant go to the planning board.
Having the different requirements between the applicants one can't get one without the other, yet the other got it and then had to go to the planning board.
So it is the timing, as Justice Sullivan is suggesting.
Yes, Your Honor.
Yes,
And
it's
my
the timing.
client may have, in fact, wished to go ahead and bear the burden, but there was nothing that showed that they were going to even be considered for a host community agreement. So at that point, they withdrew all of the stuff that they had been
Justice
securing.
Singh has a question.
So does an improper purpose have to equate with something that's unlawful?
Say that again, Your
An
Honor?
improper purpose or an improper means, does that have to equate with something that's unlawful?
Well, I think that not abiding by the statute, the disparate treatment, and all of the elements that we talked about is the, one, it is unlawful to disregard the statute and allow somebody to go ahead and do something that they shouldn't be allowed to do based on the definition within the statute. And two, I think that discrimination, well, we can call it discrimination, but discrimination, the bad faith, and just the disparate treatment can rise to the level of malice as well. I think his actions rise to that level, but they're certainly improper. No one is going to tell you that they're coming out and going against you or holding you back for a specific reason. It can be inferred by the actions, and courts have said that it can be inferred by the actions.
And just to clarify, in terms of improper motive, what are you saying is the improper motive behind this?
I say the improper motive was that he had to go through, that he would rather have the bigger companies come in rather than the smaller companies. EE applicants across the country, across the state, have had a minuscule amount of applications approved, to the point where the Senate, the legislature, has enacted new legislation where the law says that the municipalities may put together programs to unfair equitable treatment of EE applicants, to now saying that they shall put in programs to allow fair and equitable treatment of EE applicants because they weren't getting looked at all. Very minuscule amount.
Okay.
Thank you, Your Honor.
Thank you very much.
Good morning. May it please the court. Adam Sims for the City of Amesbury and Mayor Gray. I think a good jumping off point would be some of the questions posed by the panel a few moments ago. Justice Sullivan, you asked if there was any opposition from any city councilors to the other two applicants. Nothing that's in the record. Justice Singh, in response to a question of yours about the malice standard, my brother counsel referred to the SJC decision in United Truck Leasing, which I would point out in itself is not an employment decision. And the malice standard was applied in that case. Justice Sullivan, you also pointed out that in footnote 3 of the underlying decision on appeal here, Justice Lang pointed out that the plaintiff had not challenged the malice standard at the summary judgment stage. Moreover, the plaintiff hadn't challenged the actual malice standard when we moved for motion for judgment on the pleadings. So this issue actually came up twice at the trial court level. The first time it was raised was at the argument on the motion for summary judgment.
Well, I did see something in their pleadings regarding malice with respect to the qualified immunity issue. So is that enough?
I'm sorry, Your Honor.
I saw something in the pleadings before the motion judge that referred to malice in the context of the issue of qualified immunity. So is that enough to raise the issue generally?
I would say not. I mean, if there was a fleeting reference with no further discussion and no explanation in terms of trying to distinguish case law either from this court or the SJC, I don't think that preserves the argument on appeal. And with apologies
But if malice is the wrong standard, that doesn't prevent us from using the correct standard, right?
That's correct, Your Honor. With apologies to the court, I did not cite this case in our brief, but there's a case from this court not that long ago, two cases actually. Brewster Wall Covering, 68 Mass Appellate Court 582. That's a reported decision, which was a dispute between a distributor and a manufacturer involving the distribution of wallpaper, where this court did apply the actual malice standard in an intentional interference claim. Clearly not an employment case. And then more recently, an unreported decision, TH Claims versus the Town of Hingham, 84 Mass Appellate Court 1124, decided in 2013, in which this court upheld a motion to dismiss from the lower court. And one of the claims in TH Claims was intentional interference with prospective relations, contractual relations. That in TH Claims is a well-known, a very large developer on the South Shore, has nothing to do with employment, an employment case. So I have been able to find at least two cases that we just cited, one reported, one unreported, where this court did apply the actual malice standard in a non-employment setting. And just for a moment, with respect to what the SJC has said, these cases often have to be reviewed in the totality of the circumstances. The underlying court made the following in its decision on the MSJ, that the record appears bereft, his language, not mine, the record appears bereft of any evidence of personal animus that Mayor Gray had toward the plaintiffs. And combining that with what the SJC said actual malice constitutes in Blackstone, whether the controlling factor, in their language, not mine, whether the controlling factor in the defendant's interference was actual malice. That is a spiteful, malignant purpose unrelated to a legitimate corporate interest. Well, there's no showing, nothing remotely approaching either of those two prongs in the record before this court.
We may end up agreeing with you, but for now, my question is, the plaintiff here was treated differently. Is that fair to say?
No, I don't think the plaintiff was treated.
Were the other two entities that applied, were they sent to the planning board before they were able to proceed with the mayor?
They were not, Your Honor. And
okay, so they were. So that is a difference. Is that right?
That is a difference.
Okay.
I don't mean to mince words, but treated differently. In my mind, someone who does a lot of equal protection type claims has a certain ring to it. Here, to adopt
they required to do
terminology,
something in a different manner at a
Yes.
different time than the other two.
And
Were the
for
other
good
two
reason.
entities, did they have EE status?
The other two entities, one, ATG had the equivalent, has a medical, I forgot the exact terminology, but a prerogative or a preference before the Cannabis Control Commission because it was providing marijuana for medical use. So not EE status, but also a preference.
Yeah, there's a big difference between EE status and medical use. I mean,
Yes.
The argument, as I hear it, is because we're a disadvantaged group with EE status, we're made to leap a higher bar than anybody else because they don't want us. And that's malice.
And Your Honor, again, the record was very clear as to why that happened. The plaintiff started the process. Again, there's no dispute that within the process, the three requirements, the community outreach agreement, a community outreach meeting, the host community agreement, and site plan review. Those are the three requirements basically to complete the application before the CCC. But it's in agreement. There is no statute and nothing in the zoning bylaw or ordinance which says the order in which the plaintiff or the applicant has to pursue those three prongs.
So again, the question is, why was this particular entity required to follow a different order, or why was a different order imposed upon this entity?
Simply because Mayor Gray received very differing accounts of how the plaintiff's community outreach meeting went. The plaintiff said it went fine. I was able to answer all the questions. Not only did some residents state otherwise, but the city councilor, whose very district includes the location where the plaintiff wanted to operate,
So you're
told
saying
Mayor,
it's
I was at that
community
meeting,
objection.
it did not go well. And that's it. That's what's in the record. That's why Mayor Gray said, well, look, you have to go to the planning board eventually anyway. It's not like you get to skip site plan review. go to the planning board, wholly independent body of which the mayor has no authority. The mayor doesn't review decisions of the planning board. There's a statutory right of appeal to the Superior Court if you don't like the decision of the planning board. Have the hearing before the planning board, which is open to the public, unlike a personal meeting with the mayor, where he was literally handed agreement and said, will you sign this, with no advance notice. Go to the planning board, work out whatever their issues are with respect to traffic, with respect to any security concerns, hours of operation.
What do you say to the argument that they couldn't go there?
I think we addressed it in our brief, and I think that's just incorrect. The ordinance makes a very big difference between the ability of an applicant to start the process with the Cannabis Control Commission, that is, submit an application, which to some extent had to have been done, because we know they have EE status. And we have the affidavit of Kyle Potvin in the record, who's the only person who provided any testimony, if you will, on behalf of this CCC. There's a very big difference, Your Honor, between starting the process, that is, filing some portion of what you hope will be eventually a full application with the CCC, and completing the process.
So you're saying there was no catch-22?
I don't believe there is, and I would refer Your Honor to the ordinance I know is in the record, and it's section 10.01, I believe. Yes, 10.01, which is conditions of approval, 10.01E, the paragraph on host community agreements, which Justice Howe and Justice Lang both said contemplates going to the planning board before one obtains a host community agreement. So I think the plaintiffs are just wrong that they could not have even gone to the planning board to seek a special permit without first having a host community agreement from the mayor. The ordinance itself suggests otherwise. Both Superior Court justices who heard dispositive motions in this case found to the contrary. If I might then turn to I think the other big issue in the case, qualified immunity, which Judge Lang said was an alternate basis for his decision granting a motion for summary judgment. For whatever reason, it wasn't addressed by the plaintiffs in their brief. So I can only assume from decisions of this court that the plaintiffs are not assigning any error to that part of Justice Lang's decision. It's deemed waived. I would not have the temerity to tell this court what it can or cannot do, but
You can try.
I'm not aware of any decisions where the court has reversed a legal conclusion in favor of summary judgment, which was then not addressed on appeal by the appellant. And that's as far as I think I'll go on that, Your Honor. Again, with apologies to the court, there's a decision, Goudreau versus Nikes. I think, Your Honor, Justice Vuno, I think you were part of the panel, 98 Mass Appellate Court 266, decided just in 2020, in which the court did apply qualified immunity in a case involving tortious interference with contract. It doesn't come up a lot, but that was at least one published opinion I was able to find. I know there's been no discussion of the other claim left, the Declaratory Judgment Act. I'm happy to rest on the papers unless the court has any further questions for me.
I see no further questions. Thank you both very much for your arguments and your briefs in this case.
Thank you.
Take the case under advisement. All right, the next case on our list today is case number 2022-0479, Trustees of Boston College versus Boston Academy of the Sacred Heart. Okay, good morning.
Good morning. I'm ready when you tell me.
We're ready.
You're good. May it please the court, my name is Sander Reclean. I represent the defendant and the appellant here, Boston Academy of the Sacred Heart. The only people who call it that are the lawyers. It's what everybody knows as Newton Country Day School, an all-girls school, Catholic school in Newton. At council table is Danny Gunther, who's helped me on all the papers and at trial. And in the front row, we have the headmistress of Newton Country Day School and two of the nuns who are part of the religious order that has always run Newton Country Day School. It's a matter of significant importance to them as well as to the lawyers before you. This case is about rights to use Colby Street. It's a private way between the campuses of Newton Country Day School and the Newton campus of Boston College. And the case law tells us that this is a search for the presumed intent of the grantor. What rights Newton Country Day School got, Boston Academy of the Sacred Heart. What rights it got depends upon the presumed intent of the grantor. We submit that the judge erred in the land court when he confined his analysis to looking only at the two deeds in question and not to the surrounding circumstances, even though the case law instructs that you can look at the surrounding circumstances. And the surrounding circumstances in this case are substantial because although the transaction took place in 1974, to dissolve Newton College, which is what gave rise to this transaction, to dissolve Newton College, they had to go to the SJC for a court-supervised dissolution. And to do so, there was a petition filed with the SJC. There was...
Where in that petition can we look to and point to say that the intent, as you are, as you emphasize, and whether or not that's the case, we can discuss a little bit later, whether the intent of the grantor here, the prior Newton College, was to give access to Colby Street to, what I refer to now as the school, to make it easier.
That's clearly the question, and you can search all of the documents at the SJC, and there is no reference to use of Colby Street.
Okay.
But
Please continue. Mm-hmm.
What there is reference to, repeated reference, is that the deed to Newton Country Day School was to take place first, and the remaining assets were to go to Boston College. The petition, which is part of the record.
But what real difference does that make when the entire dissolution of the property was organized together, presented together, in layman's terms, sort of in one fell swoop?
All right,
right?
So the importance is that for real estate rights, typically order of conveyance matters. And
these deeds were filed in the same minute, right?
Yes, they were not filed sequentially. There's a timestamp on the deeds, and you have the deeds in the record.
So how do we, I mean, this case boils down, one of them, they couldn't both hit the timestamp machine at the same time. So from whence do you derive this notion that when they're filed in the same minute, the sequence matters?
Okay, so I have several answers to that. The first is that the petitioner at the SJC, Newton College, specified in its prayer for relief that the conveyance to Newton Country Day School would go first. The decree of the SJC specified that the conveyance to Newton Country Day School would go first. The case law talks about rights. The two doctrines I care about predominantly are the derelict fee statute, which talks about when you convey abutting away, and if you own title to the way, your right transfers with the property. The derelict fee statute cares in what order deeds.
Before you get to the derelict fee statute, could you just point to me, I know there's a parcel 1 and a parcel 2. What is the precise language, and I'm sorry if I missed it in the briefing, it's entirely possible, that says that one conveyance is to happen before the other.
Okay, so you're talking about where in the record?
Yeah.
Where in the record?
You mentioned three
I'm
places.
going-
If you have those 3 points, that would be helpful.
We'd just like to have the 3 references so that we can.
I'm got them here.
Okay.
The original petition to the SJC, you will find it, the particular page I'm going to quote you from is Appendix Volume 2, page 71, paragraph 1. The prayer asks that the court enter an interlocutory decree allowing petitioner, that's Newton College, to transfer to Boston Academy of the Sacred Heart, that's Country Day School, certain real estate. And then that prayer ends by saying, and to transfer and deliver all the remaining assets subject to all of its remaining liabilities to Boston College.
I'm not hearing where it says that the deed to the school needs to be recorded first.
Well, you can't convey remaining assets unless you've transferred some other things. The Newton College at that point owned the land that was historically the campus of Newton College. It owned what was historically the campus of Newton Country Day School, and it owned 2 residences that nuns were living in, not contiguous to these parcels. And the plan was, we're going to reconvey land to Newton Country Day School so it can stand on its own again. We're going to convey the 2 homes to Religious of the Sacred Heart in Massachusetts, the religious order, and what's left goes to BC. The prayer for relief in the petition clearly says that order. Newton Country Day School, then Religious.
But what's left is described in the deed to Boston College, and that
What's left?
deed describes all of Colby Road, whereas the deed,
it says
whereas the deed to the school does not. So that's why I'm not understanding why this is so important or critical to your argument.
It is important for 2 reasons. One is because presumed intent matters, and we are arguing that you can find the presumed intent in the proceedings at the Supreme Judicial Court. The second, with respect to rights to use Colby, it has been argued by Boston College that if our deed wasn't properly first, then there were no rights to use Colby left, and so Newton Country Day School couldn't use Colby, even though it abutted Colby and had historically used Colby. And finally, with respect to your comment about the deed to Boston College referring to Colby, it doesn't say, and we grant all of our interest in Colby. It lists a series of streets. This is Appendix Volume 2 at page 249. It's the second page of the deed to Boston College. It says, conveyed with all of grantor's right, that's Newton College, title and interest, if any, in Center Street, Mill Street, Colby Street, Westchester Road, Rochester Road, and Everett Road. It wasn't saying we have these things. It was saying this is all encompassing. Whatever's left, if any, goes to Boston College. And that was what the petition had asked for, the petition to the SJC.
How did the deed describe the boundary did not the deed to the school describe the boundary as
It says along the northern border of Colby Street.
So what remains after that? The rest of Colby?
Under derelict fee.
No, that's not my question. At that point, right, that's where the boundary is. At that point in time, the remaining land does not include all of Colby Street.
Depending on application of derelict fee.
Which basically you think sort of comes into place within this 1 minute in between the 2 deeds being filed, if I understand correctly.
I would say it doesn't matter if it's 1 minute or 1 hour or 2 days.
In this case, it happens to be. That's what we're talking about, right?
Under derelict fee, presuming the deed to Newton Country Day School goes first and was properly first. Under derelict fee, when you convey along a way, with the deed comes title to center, if you own on both sides.
They did not, so, you know.
And so we've argued from the very beginning that with the deed to Newton Country Day School, which was in fact recorded first, that's not disputed, that with that deed came the rights to the center line. But I want to make clear to the court, it's not important to us who owns the fee in Colby Street. What's important to us is the right to use Colby Street. And as an alternate argument, we've argued at all times that by derelict fee, we were properly recorded first, we own to the center line of Colby, and with that comes complete rights to use Colby Street. This matters because Colby is a private way, it's not a public way. And we have argued that under the easement by estoppel cases, when you are conveyed land along a way, you get the right to use the entirety of the way, both directions, entire length and width. And the critical issue for the school is the ability to use Colby as it had used historically.
Well, they're not using it now as they had historically. Historically, some senior women who were attending the high school would park their cars there upon occasion. And now with the construction of the wellness center, now you have many cars, buses, and things of that nature going up and down.
There are two unrebutted, uncontested.
So it's fair to say the historical use has changed. I just want to make sure that I'm clear.
Current use is not the same as it was before. The wellness center didn't exist. However, there are two affidavits of nuns who were around in the 1970s, whose affidavit are unrebutted. This is Sister Hughes and Sister De La Chapelle. De La Chapelle is sitting behind me.
Right. Welcome.
The sisters said that even in the old days, before the wellness center, there were athletic fields and vehicles would come down Colby, would turn in and park near the athletic fields for athletic events.
Sure, that's not disputed, but there's a big difference between the use in the 70s and the 80s with respect to that street by the school than when they built the wellness center. And of course, the record also indicates that there was a statement made by the school that they would not use Colby Street for access to the wellness center. Is that correct?
During permitting, which was advisory only because this is a Dover use, a protected school use, during permitting with the city of Newton, the representation was made that, and I don't remember the precise words, but it was something to the effect that for the time being, we're not going to use Colby for access. But the critical question...
I think actually it was, more specifically, we are not going to use it for general access. It's going to be used for emergency use only.
The letter from permitting council is part of the record, and you have it, and
Yeah.
And
that's my recollection.
the issue, I think we're a little afield from
Well, we were talking about historical use, and so we did get a little bit afield, yes.
It's important to point out, the question the city asked, but at that point there was already a dispute with Boston College, and the question the city asked is, what happens to your project if you litigate with Boston College and you lose, and it turns out you have no rights to use Colby at all? Does your project function? Or are we giving you permission to build a big wellness center and
it's going to be cut off, right?
And it's going to be cut off. Will your campus function? Those vehicles have to come from somewhere and go to somewhere. How's your campus going to function? And so the discussion, it's covered in the Michael Peirce affidavit, which is part of the record. But the discussion with the city then became, okay, fire department, if we had to cut it off and we used it for emergency access only, would that work for you? And they had to check with the police department. If we had to cut it off and use it for emergency only, would that work for you? And ultimately, when public safety said, yes, that would work for us, the application was made not knowing what would happen in the litigation, the as yet unfiled litigation with BC, that we'll use it for emergency only.
I have one other question for you, and your time is almost up. There's another fact that you rely upon, which is that letter that was written by counsel for Boston College in 1988, and I'll try and make this quick because you have under a minute. I feel like I'm on a radio show. In 30 seconds, could you please tell me the answer to this question? But there was that letter that was written that says that the school has access to Colby Road. Why can't we not interpret that as meaning that the school, as well as the public at that time, had access to Colby Road. I mean, Colby Road at that point was a private way, but was always open to the public.
My answer is that the city planning people in Newton were asking for a specific condition in a subdivision approval. I'm reading now Appendix Volume 3 at page 230. They wanted a binding condition that said that adjacent landowners should be permitted access rights directly onto Colby Street from the Sacred Heart Country Day School site. And the response from council was, the school already has rights to use Colby Street.
Right.
We suggest to the court that that's a statement of rights, not a statement of permission.
Okay.
And say we've been permitting the school to use it. It says...
I hear your argument, yeah. I hear your argument. Your time is up, so I'm just going to check to see if anybody else, all right. Your brief was thorough, so nothing is going to be left on the table. Don't worry, everything in your brief will be considered.
We would like to rely on what's in our brief and our reply brief, and the relief we seek is fully described at the end of both of those.
We're fully aware. Thank you very much for your argument.
Good morning, Your Honors. May it please the Court, Richard Otheimer for the trustees of Boston College, and with me at council table, Edwina Clark, who worked on the briefs, and I'll just sort of acknowledge Michael Murray, who tried the later case and worked on summary judgment with me, has changed firms, but he cared enough to come and join us here today in the back benches. Your Honor, it's somewhat remarkable. This closing happened almost 50 years ago. I was enrolled in Boston College later that year, but we go back to June 1974.
And little did you know at that time,
Little did
right?
I know, right? Yeah, I was on the campus that fall. And remarkably, when this case was filed, we were able to retrieve 4 copies of the closing binder. I'm not sure that would happen today, but Goodwin Proctor had a copy, Boston College had a copy, Ropes and Gray, which had represented Newton College, had a copy, and the Religious Society of the Sacred Heart had a copy. You have the entire closing binder in the record. It begins at page 93 and goes for 150 pages. The entire case here, just so we're clear, derelict fee, easement by estoppel, everything, all their arguments depend on the court determining that their deed is, quote, first, quote, unquote, when the only evidence they can point to is that they appear on an earlier page when they were handed over the counter in the same minute at 3:52 p.m. the day of the closing. But under the case law, it has to be separate. If this is one, I think, Your Honor, Justice Sullivan, you call it one fell swoop.
Yeah.
And of course,
I think that poor reference was mine, so don't attribute
I'm sorry.
that. Don't attribute
I
that to
apologize.
Justice Sullivan.
It's a good one.
when we look at the closing binder, and it begins at page 93 of volume 2. And it's easier for me to find the pages. I actually have a copy of the closing binder here. We have a letter from Newton College's counsel, Ropes and Gray, circulating a binder containing copies of the documents executed at the closing. And the cover at page 93 reads, Newton College of the Sacred Heart, transfer of assets to Boston College, Boston Academy of the Sacred Heart, and Religious of the Sacred Heart in Massachusetts, Inc., June 28, 1974. Interesting, and we've noted that Boston College is listed first. I don't really attribute any importance to that. If you go through the record, sometimes they say the assets and the remaining assets to Boston College, and sometimes they say it the other way around. But in terms of whether this was, it clearly was a joint closing. We have the closing agenda. We know everyone who was there. But it was a coordinated transaction, and not only was it, it had to be. 2 years before this, and Newton College's financial problems did not crop up overnight. And 2 years before,
Where did you say the page was that you were just reading from the cover letter?
93. 94 it should be, actually.
The cover is at volume 2, page 93, and the transmittal letter's at 94.
Thank you.
And then if we turn to the closing agenda at 96, it lists all the participants. And obviously, we had the law firms of Goodwin Proctor, Ropes and Gray, Bingham Dana, all representing parties, Newton College, Boston Academy, which is Newton Country Day School. And we have a listing of all the exhibits. And we've noted before in the papers that the Boston College deed is at tab 13, and the Newton Country Day School or Boston Academy deed is at tab 17, so it's later. And you might infer that documents were executed in that order. That doesn't matter either. These are simultaneous deeds as part of a coordinated joint closing. And they had to be. 2 years earlier, when Newton College was having financial difficulties, and this is a stipulated fact in the joint statement of agreed facts, they conveyed their campus, the day school, what we'll call the day school campus, Lot B1, to Newton College, because Newton College needed to pledge additional security to the bank for its mortgage debt. That's why the fact that all the both campuses were in the name of Newton College is really an artifact. And Newton College mortgaged them. They rely, the nuns relate, the nuns who provided affidavits relate conversations with a deceased nun, Sister Sweeney, who said that the purpose of 1974 was for the day school to get its campus back free of debt so that it could operate independently again. And it did. And you know how it did? Under their deed is number 17 in the tab, warranty deed from Newton College to Boston Academy, 17 plus acres that are the subject of the partial release. That's tab 17. Tab 16 is the partial release by Newton Savings Bank of its mortgage on the properties which are to be transferred to Boston Academy. So Newton Savings Bank released Lot B1 from its mortgage. Why did it do that? The answer to that is at tab 14, Boston Assumption Agreement, by which Boston College agrees to assume the outstanding obligations of Newton College to the Newton Savings Bank, and there was another mortgage. Why did Boston College do that? Because on tab 13, it got deeded Lot A1. It wouldn't have assumed the debt without getting the land. Unless it assumed the debt, the bank wouldn't release its mortgage, and Newton Country Day School couldn't get its campus back free of debt. So not only did this transaction all happen together, it had to. That was the only way Newton Country Day School could get its campus back, free of debt. And the deeds are very clear, and in fact, when you look at the partial release of mortgage, which is at volume 2, 189, what Newton Savings Bank released from its mortgage was Lot B1, matches exactly with the description in the Newton Country Day School deed. It's the northern edge of Colby Street. And by the way, the northern edge of Colby Street is where the fence is and where the boundary line was placed 10 years before when the college and day school campuses, without any involvement in Boston College, this was in 1965, they recorded a plan in land court and put the proposed boundary line between the two campuses where there is a long-standing chain link fence that's been there as long as anyone can remember. Colby Street, the private way Colby Street, is entirely on the Boston College, the college campus side of the fence. In fact, there's an 8 to 10 foot grass strip between the paved portion of the road and the fence. When this dispute arose, Boston College commissioned a survey by Feldman surveyors, and they confirmed that the boundary line established in the two deeds at the 1974 closing tracked the boundary line in the 1965 plan, tracks the line of the chain link fence, which puts the road entirely on the Boston College Newton campus, and the entire Newton Country Day School campus, Lot B1 in the deeds, inside the fence, on the northern side of the fence. You may be familiar with, if you've been out there, if you're coming from up Center Street from Com Ave towards the Pike, you first pass the main entrance to the Boston College Newton campus, then Colby Street, there's a street sign, and it's how you drive into the Boston College athletic fields, the lacrosse and soccer fields, and it's fence separating it from the campus of Newton Country Day School, which is further north, and by the way, has ample access. As the judge found in his decision, they have more than 2,300 feet of access on public and private ways, on Center Street, the main entrance, off Richmond Road, Academy Road, I think the judge missed that, and Westchester Road. And in fact, this is outside of the record, but since they lost the prescriptive easement trial in 2021-22, they've actually constructed a new driveway into the Wellness Center off Westchester Road. To respond, I guess, briefly to a couple of the points, the SJC action, it is a voluminous record. They put in the whole, I just say, each way it worked below is that each party put whatever they wanted in the summary judgment record. We reserve the right to sort of object to relevance and how much weight it deserves. So I didn't put any of that in. I think the...
Well, and these deeds show up perhaps only in one place or in more than one place?
The deeds?
Yeah.
They show up, the signed deeds, signed copies of both deeds are part of the closing binder that was circulated after the closing.
That's what we should...
Well, I went and sent a paralegal to the Middlesex South Registry of Deeds to get the recorded instruments because I was curious to see whether they recorded 2 minutes apart, 3 minutes apart, a day apart, and they both had a timestamp of 3:52 p.m. On the day of the closing. Okay. So there is a separate time-stamped copy.
And there was a reference at one point in the briefs to the documents that were on at page 20-something, but I think those were some previous deeds, some historical deeds.
They put in a lot of the historical, and you actually have the 1972 deeds by which Newton College acquired the interest, but the two deeds were signed at the closing. They were recorded the same day. You have timestamped copies in the record. It's a stipulated fact that they were both recorded at 3:52 p.m. Their deed at page 286 and the BC deed at 294. 21, that's the 1965 land court plan, Your Honor.
Okay. And on the land court plan, I looked for a compass just to find where true north was. I may not be able to read it if it's that small, but is there a sense of where true north is on this plan?
I can tell you, and I wonder, I do have larger copies of the plan that I can provide to the court at the end of the argument.
I'm not sure that there is a compass on this plan.
No.
But does everybody agree that this is?
I think everybody agrees. Everybody agrees that the northern edge of Colby Street is what borders the campus. In other words, when you're coming from Com Ave
the BC
to the
campus.
Pike, right. The BC campus, the college campus, is south of Newton Country Day School. North is the direction of the Mass Pike. And so the northern edge of Colby is the southern edge of the Newton Country Day School campus and the northern edge of the Boston College Newton Law School campus. And on that plan, lot B1 and the sort of odd-shaped, I've called it sort of Hogwarts-type building is the Newton Country Day School building. There are more buildings on the college side of the campus. But that plan was recorded in 1965 by the Religious Society when they were in sort of common ownership and control of both Newton College and Newton Country Day School. I want to address briefly the SJC action. As I said, it's a lot of paper in the record about that. We didn't put the whole summary judgment hearing transcript in the record. I appreciate this is de novo review, but I will quote what Land Court Judge Speicher said. He found the deeds unambiguous and parole evidence inadmissible, but yet he did, and it's clear in his decision, that he reviewed everything that counsel referred him to. And his response to that at argument, when Mr. McLean said the Supreme Judicial Court's orders, he said, the court, Judge Speicher said, it just said you're going to do both. I don't think it said do one after the other. In other words, the SJC gave permission to close Newton College, to dissolve the charitable corporation, and dispose of its assets. And that's what was done, and everything was consistent with Newton Country Day School is going to get its campus back free of debt. Boston College is going to assume the Newton College campus and assume the debt, which it did. Briefly, the 1988 letter, Your Honor, Your Honors, doesn't bear on intent. It's 14 years after the closing. The lawyer who wrote it was not involved in the 1974 closing. He was at a firm, Rackham & Sawyer, that was not involved in the closing. He wasn't deposed. No effort was made to determine.
He had any memory or was still alive or whatever.
He's still alive. No memory.
Well, that's probably outside the record, so, but
It
I
is,
appreciate, but
it
we'll
is.
put that in
But
this box.
There's certainly no evidence in the record of what he was referring to. The city of Newton, as Your Honor mentioned, had determined that there were public rights to use Colby Road for access to Edmonds Park. Again, this is sort of outside the record, but I think the court can take into account that at the prescriptive easement trial, which Boston College won, Judge Speicher found that Newton Country Day School used Colby Road all through the 1980s.
I read his decision, yeah.
So he could have been referring to permissive use, he could have been referring to public use. We don't know. And if we're going to, they accuse BC of changing position, as long as we're doing that, and I have a few seconds left. Before this suit was filed, counsel for Newton Country Day School wrote to Boston College. They ordered a title commitment and wrote from Commonwealth Title, and based on the commitment, wrote to Boston College General Counsel. There's a letter in the record at page volume 4, A103. Charles Rogers of Edward Wildman, brother of Sister Rogers, the headmistress, said the Commonwealth commitment says what it says, and accordingly, Newton Country Day School acknowledges that the fee to Colby Street is owned by Boston College. Further acknowledge that the boundary line is as set forth in the survey.
Well,
Finally,
well, your time is up, and I'll just say that we, of course, will look at all of the record very, very carefully. Look at the law. We'll be the ones who will have to decide unless the SJC wants to decide otherwise what happens here. But I guess what's left for all of you to figure out is how everybody can get along again. That's not our job. That's your job. So
the gate emergency access, which BC was okay with, is still there. So I agree, Your Honor, and thank you for the court's time.
thank you all very much. Thank you all for also coming and for your interest in this case. We appreciate it, and we'll take the case under advisement. Thank you very much. All right, I'll call the next case and the last case on our list for today. I want to remind everybody that this case is impounded, so I'm reminding the attorneys that they must use their pseudonyms and not the parties' names. So the case is number 20-22-0189, Department of Children and Families versus Another End Mother.
Good morning, Your Honors.
Good morning.
My name is Tamika O'Brien on behalf of the appellant mother. Your Honors, this is the second time this case has been on appeal. The first time this court, in adoption of Eileen, determined that the findings of fact issued by the lower court were thin and did not meet the standard required in Care and Protection EN, that findings of mother's overall parenting capabilities at the time of trial lacked specificity and detail that's required in these kinds of cases. The trial court, having a very clear order from this court, then attempted to clarify her findings by adding a paltry 10 findings to the original set. Your Honor, mother contends that these findings, the second set of findings, still do not meet that standard, and that proof was not full, clear, and decisive in this matter. Further, the mother argues that the trial judge did not even-handedly consider the evidence or pay close attention to the evidence in this case. DCF, when they filed their original affidavit, they filed their affidavit in this case, their complaint was that mother had left the child with an inappropriate caregiver. And the trial judge, in conclusions 4, 6, 7, and 38, concluded that this was true. But what wasn't mentioned was that at the time that mother left the child in the care of the paternal grandmother, no one, not the probate court, not DCF, considered the paternal grandmother to be an inappropriate caregiver. It wasn't until paternal grandmother was found to be letting father, who was not allowed to be anywhere near a child under 16, into the house, that DCF determined that this was an inappropriate caregiver. In this case,
Correct me if I'm wrong, and it's hard to tease this out, but there's 2 instances of leaving the child.
correct.
One was leaving the child, if I remember correctly, with her mother when her mother had stated that she did not want to care for the child.
Right.
And I thought the 51A on that was the 51A for leaving the child with an inappropriate caregiver because it was an unwilling caregiver.
I think that you, and you're right about teasing that out, I think that you might be correct on that. I think that, I apologize. I think that the second time, now that I think about this, is that the second time that mother didn't return when she said she was going to return. So thank you, and I apologize on that.
No apologies necessary. These cases are complex, and I'm sure you have a lot of them, and that's why I asked the question, because we get a lot of them too.
Sure.
And I just want to.
And this is unusual in the
If we all get on the
sense-
same page, it's so much the
Thank you.
better, right?
Thank you. That's very generous. This is also an unusual case that this is the second time that this is on an appeal. And, I think what is really important here is to look at, we're all here to look at the findings and see what's going on. And this morning I sat down and I looked at all of DCF's complaints that, not to mention the caregiver, but that mother was not organized. And the trial court in findings 37, 39, and 40 and conclusion 17 agreed. But the trial court did not, in her findings, mention any of the testimony of DCF's social workers saying, well, we didn't have any services for mother to improve on those organization skills. We didn't offer her any. And while that is something that, should have been addressed at the trial court level, also what wasn't mentioned in the findings was that the mother was going to a parenting journey group to learn to better parent, and that counselor that mother saw told the court investigator that mother was actually the organizer of that group. So her organization skills were improving. And again, that's a little thing, but all these little things add up, as we know.
Can we concentrate, though, on the big things?
Sure,
Because
sure.
this is a hard case, in part because of the absence of evidence.
Sure.
The department says, I saw the list of 12, and there are undoubtedly some things in that list that are primary and some that are secondary. I would hope that the department wasn't taking the child away because she didn't fill out a spreadsheet.
Sure.
But let's look at the primary ones. Failure to do neurological testing, failure to consistently attend mental health counseling, and concerns about substance abuse. How do we say that the judge's findings are unsupported when the claim is that the mother didn't follow through on the things that would have provided more information to the department with which to assist?
Sure. I think that one of the big things here is that the trial court mentioned multiple times that mother didn't address her possible substance abuse. But in this case, there wasn't any proof that mother had a substance use problem. The
Well,
child
There
was,
was a 51A which was supported. Are there any unsupported 51As in this? As I read the record, I think they're all supported. Are you?
I think that they are all supported, but I think it's really.
So there's a supported 51A that says she was intoxicated while caring for the child.
There was, but I think that it's important to note that the DCF never saw mother under the influence. They didn't have any, the social worker, nobody ever stopped any of the visits because that mother was intoxicated or under the influence. The child was, mother found out when she was 5 months pregnant that she was pregnant. So when there was some prenatal testing, she did, her test results did indicate marijuana and cocaine, but the child was born substance-free. Mother went to Arbor Counseling as requested by DCF, and Arbor Counseling made no recommendations that mother should go for substance counseling or made any other referrals.
How long did her participation in Arbor Counseling last, though? Is that the counseling that she says was terminated? She testified was terminated?
I believe so.
So could the judge infer from the failure to complete treatment or attend treatment consistently that there was a substance abuse issue? Could she have inferred that? I'm not saying she did, but could she have?
She could, but our argument is that there was never any nexus showing that mother testified that she smoked marijuana. That I think she had smoked marijuana maybe a month before trial. But there was never any nexus shown, as required by Imelda, that her substance use directly impacted her parenting capabilities. As far as also, mother had signed releases, and there was testimony by the social worker that he hadn't contacted the counselors to talk to them about what was going on. So in a sense, that was shifting the burden to mother to prove that she didn't have a substance use disorder. Mother was asked to do neurological counseling, and she did not do that, and those are the facts. And I can't argue against that. But if you look at the case as a whole, and we talked about the little things add up. And in this case, when you look at the little things, like the organizational skills, the budget, the releases, housing, DCF complained that mother had unstable housing. Well, she was living with her mother in a 2-bedroom apartment. They complained that she didn't have employment, and therefore the concern was that she could not provide for her child, but she was being supported by her mother. And, you know, perhaps at 23 years old, mother who had a new child should have been employed, and she wasn't, but she was not without help. And this is a big problem in some of these cases where DCF complains that the parent doesn't have the appropriate support system. But then when they do have the support system, it's, oh, well, she's relying too much on mother. And that's pretty unfair in these kind of cases. We are looking at a young mother. We are also looking at a case here where the child was removed from mother's custody at the end of April of 2017, was placed into the custody of the paternal grandmother middle of June 2017. 2 weeks later, it was removed, and then 2 weeks later was placed into this kinship foster home. And then 6 short months later, the goal was changed from reunification to adoption. And I think that doesn't allow mother a whole lot of time. Mother testified that she wasn't prepared to take custody of the child right now. But she had engaged in counseling. At the time of trial, she did testify that she had secured a position at a taxi cab company answering phones. And again, I think that when you look at the findings in this case compared to the findings, the first set of findings, adding 10 findings doesn't make this case any stronger than it was the first time we were here. And I think that that's really important, because if the evidence was there, I feel like the trial judge would have, we have adoption of Eileen, and that's a pretty straightforward order of, here's what we need to see so that these findings are specific and detailed enough to terminate this relationship, this family bond. And then the trial court judge only adds 10. That's not, if, in these kind of cases, there's usually so much evidence that we're looking at hundreds and hundreds of findings. But to only add 10 after you were specifically told we need more, I think we're where we were in adoption of Eileen.
So your bottom line is that you say that the findings weren't thin, the evidence was thin.
The evidence was thin. Your Honor, I have a couple more minutes. If you have any questions, I'm happy to entertain them. If not, I will rest on my brief.
Thank you very much.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Julie Green, Assistant Attorney General representing the Department of Children and Families. I'll be splitting my time 10 minutes, 5 minutes with Mr. Ferguson, Attorney for the Child. This case is before the Court on clarified and more detailed findings following remand. The case was originally tried in December of 2018 when the child was 3 years old. It was reviewed by this Court, and it was remanded with specific instructions to provide more detailed findings. But I want to draw your attention to what the Court said in its remand decision. The Court stressed that there is sufficient evidence in the record to support the judge's conclusions with respect to both unfitness and the best interests of the child. But it pointed to the fact that the Court's findings about the evidence in the record were unusually thin. And it specifically pointed to findings concerning the events that precipitated the child's removal the second time in the instant care and protection proceeding in March and April of 2017. The Court then, without taking new testimony, issued clarified findings and conclusions. And specifically, the clarified and more detailed findings fill out the record with regard to the events that precipitated the removal. The Court also provided substantially more detailed conclusions of law, explaining the findings and how they support the ultimate conclusion of unfitness and termination. And there were 7 additional conclusions of law, numbers 4, 6, 7, 12, 17, 27, and 32. And I'd particularly like to draw your attention to conclusions of law 6 and 7, which are much more detailed than last time and explain in much more detail what the basis was for the Court's conclusion of unfitness.
With respect,
So overall, what was this mother's grievous shortcoming?
The shortcoming was a pattern of irresponsibility with respect to her obligations to the child that really I would put into 4 separate categories. First, when she did have custody of the child, a pattern of leaving the child with either inappropriate caretakers or inappropriate caretaking arrangements. That is to say, caretakers who had not agreed to take care of the child and who were expecting to return the child to mother, and then mother did not appear and could not be reached. Second, once she did not have custody of the child, a pattern of failing to appear for scheduled biweekly visits with the child. Roughly a third of the visits, mother failed to appear with no explanation. Third, a pattern of failing to show up for other obligations with respect to the proceeding, meetings with the social worker, foster care review, and scheduled court dates. And then fourth, a failure to engage with the services that would have helped identify the root causes of her pattern of irresponsibility, that would have helped the department provide services, but mother failed to engage with therapy and with neuropsych and substance abuse evaluations. So why don't I address those in turn unless you have specific questions? Why don't I start with the evidence concerning leaving the child with inappropriate caregiving arrangements. Let me first stress, the court was not, this came up in my sister's argument, and I want to explain. The court did not fault mother for leaving the child with an inappropriate caregiver. The paternal grandmother with whom she was left in March and April 2017 was clearly not inappropriate per se, leaving aside the issue of her son in the house later. Rather, what the court said in conclusion of Law 7 was, while leaving the child with her grandmother was not probative of unfitness, leaving her with a third party well past the agreed-upon date and remaining unreachable after her daughter had suffered a serious injury evinces mother's pattern of neglecting the child by leaving her with third parties for extended periods of time. So that pattern manifests in a whole series of events, beginning with the first care and protection proceeding in 2015 when the child was 2 months old. That was precipitated by a 51A report that the mother had left the child with a caregiver who had not agreed to take her, or rather, the mother had not returned to pick up the child when she said she would. There was then a 51A report that was supported in March of 2017, again, leaving her.
Before you get to 2017, do we know that the 2015 report was supported?
I don't know if we know whether it was supported. We know that those were the events that precipitated the care and protection proceeding. But I don't know, we don't have a lot of information about the evidence in that first proceeding.
The notes upon which everyone relies are pretty clear about when they're supported, and this one I just couldn't tell whether it was a drafting issue. You don't have it, there's nothing else in the record other than what's at page 134.
I don't, standing here, have information from that first.
That's fine.
There isn't much information in.
You've only got 10 minutes.
Thank you. The 51A from March of 2017 was supported. That it was a situation where, again, a mother left child with grandmother, was supposed to pick her, it was supposed to be an overnight, was supposed to pick her up at 9 a.m. the following morning, did not appear, was grandmother communicated with her by phone, by text repeatedly throughout the day. Mother kept saying, I'll come, I'll come. She didn't come, and then eventually grandmother made a report to, 51A was filed with the department toward the end of the day. The second 51A was in April of 2017. Again, it was an instance of leaving the child with grandmother. In this case, the mother did not appear for 10 days after she said she was supposed to. Sorry, let me back up. She left the child on April 7th, intending for it to be for the weekend. She was supposed to return at the end of the weekend. She did not return. She could not be reached. Her absence extended for 10 days, and during that 10-day period, she was unreachable, including when the child injured herself and the hospital attempted to reach mother for medical authorization. So, that 51A honestly was screened out at that time because the grandmother sought custody, and the department determined that that it was a moot issue at that point.
What do we do with that legally? I mean, they decided they didn't need to support it because they had a plan, but how do we treat those facts?
There's evidence in the record in the department's records that were in evidence before the court, explaining the circumstances surrounding.
But can we credit them when it's an unsupported 51A?
Only to the extent of setting the stage for the ultimate removal. The ongoing social worker, the adoption social worker, Ms. Fry, did testify at trial about those events that led up to their care and protection proceeding the second time.
So can we rely on that testimony?
You can rely on that testimony, but it was a sort of fleeting reference, I recognize. The evidence, I think, is What's most significant about the evidence is that it was a repeated pattern, and that the pattern then repeated itself with respect to visitation of the child. So there was then a fairly prominent pattern of failing to appear when scheduled visitations were supposed to take place. There were, mother had biweekly visits for a period from the time of the removal to the trial period of roughly 18 months. Mother did not appear for 12 of those visits, which is roughly a third. In each case, she offered no explanation. She simply failed to appear. Third, it's also consistent with mother's pattern with respect to her other obligations with regard to the proceedings. Mother's failure to appear for 2 court dates before trial. Mother's failure to appear for 2 of the foster care review events, and mother's failure to meet with the social worker regularly. He testified that he would often go to mother's house for scheduled visits, and she simply would not be there, without explanation. So I think in light of a sort of longer, more consistent pattern, there's substantial evidence that mother was irresponsible and failed to appear with respect to her obligations to the child. And then the fourth thing I want to mention, the court also relied on mother's failure to engage meaningfully with services. Mm-hmm. Most importantly, mother was supposed to receive individual counseling that might have addressed unaddressed mental health problems, that might have been at the root of her failure to meet her obligations, but she did not meaningfully engage. She attended sessions starting briefly in November of 2017, but was terminated for non-appearance as early as January of 2018, and then resumed only very shortly within the last couple of weeks before trial. So unless you have any questions, I'll rest on my brief.
Seeing none, you can rest on your brief. Thank you.
Thank you very much.
Good morning to the court. My name is Hugh Ferguson. I am the attorney for the child. I was the attorney for the child on the prior appeal, and I've been the attorney for the child at the trial level since 2015. Some of the questions that have been posed this morning, I'd like to be in a position to better answer for you. But if I might, I'd like to just clarify a couple of things. First of all, the substance abuse evaluation that mother was directed to complete was to be an evaluation only. It didn't say that she had to attend substance abuse treatment. There was just this need to find out if substances were a problem with her. And as the court will recall from our briefs, she had positive urine screens leading up to, or during her pregnancy and leading up to the birth of the child. However, the child was born substance-free.
Was the child, I thought the evidence was the meconium sample wasn't large enough.
I'm sorry, Your Honor.
Isn't there just an absence of evidence? I thought that the evidence was that the meconium sample wasn't large enough to get to test.
I don't know that. However, she was found to not be positive. The child was found not to be positive at the time, which is quite frankly the reason that a CMP was not initiated at that time. There was a place for mom to go with the child, which was her mother's house. And then, as you've heard, there was an altercation between mother and her mother when the boyfriend was found hiding under her bed. That precipitated the first care and protection. And throughout that, she did really well. Quite honestly, she did really well. She had a really supportive attorney. She did all the tasks that were required. Custody went back, or the child was placed back with her in March. Custody returned and the case was closed in, I believe it was July of 2016. Yet less than 11 months later, she dropped her child off with the paternal grandmother, saying it would be for the weekend. And as you've heard, she did not return. I don't think the record shows that she returned at all, because we next saw mother when the care and protection was filed on the removal of the child from the paternal grandmother. So I would argue to the court, This child was abandoned. We might not even know today were it not for the child being removed from the paternal grandmother. So
Well, wouldn't we need a finding by the trial judge that mother abandoned the child at that point in order to rely on that point that you
she
just
did
made?
not use those exact words, Your Honor, but we did not see the child again from the time she was allegedly dropped off with her grandmother until the care and protection was filed in, I believe it was June.
Are you saying
July.
that there's
I'm
no,
sorry,
there's
July.
no record of not seeing
Yes, Your
that?
Honor.
And so you're inferring that, or are you saying that there's a finding to that effect?
I don't know that there's a finding, but I will certainly look for it and
Oh, we know the find's
provide
okay.
it to the
That's
court.
okay.
Thank you.
We know the record. I mean, we'll review it again. No.
A major problem with mother, she's just not organized. She testified at trial that therapy was helping her. This therapy was started 3 months prior to trial. The therapy was helping her with organization, and she said something to the effect of, now I know how to use my phone and use the calendar. But she was told when the C&P opened and the action plan was put together.
We do not, do we say that it's, that the grievous harm is being unorganized?
Your Honor, I don't think that can be the grievous fault that there is, but her being unorganized leads to her not making appointments with the social worker who shows up at her house and she's not there. She missed well over a third of the parent-child visits during the C&P. She didn't follow through on the neurological. She didn't follow through on the substance abuse evaluation. My sister argued that we never saw her intoxicated during the course of the second C&P. But I would submit to you, when you're missing half or more of visits with the social worker, you can choose when to clean up and be able to present well for the visit when you're being seen.
So you're not really saying that her problem was disorganization?
I would say her problem is disorganization. She doesn't know what to do and when to do it, because until 3 months prior to trial, she didn't even know how to use a calendar by her own testimony. The program was teaching her how to use a calendar. A very first day action plan task. Put a calendar together and follow it. And I see my time has expired. And if there's any, if you have any further questions, I will attempt my best to respond to them.
Of course, but I see no further questions. I want to thank all three of you very much for presenting your arguments today. We're, of course, well aware that this case has been remanded once. We're well aware of the fact that these cases are always difficult. We appreciate your attention to it, and you can be assured that we will give it the same amount of attention. Thank you very much. Finished. Court in recess.
All rise, please.
Hello.